Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. One last thing that always strikes me about these kinds of suits, Alicia, and you have read many of them, is the sheer effort at technocracy. So again, going to the FTC's complaint, it says the Herfindahl-Hirschman Index is a well-established method for calculating concentration in a market, and a merger that creates a firm with a market share of over 30% and that increases the HHI of the market share by more than 100 points is presumed to substantially lessen competition. And essentially, Alicia, these are predictions. And as the saying goes, predictions are hard, especially about the future. On the grocery store side, they are saying that they need this merger in order to remain competitive. The lawyers for Kroger and Albertsons are saying that they're losing this food fight, and that if they aren't able to put this merger through, there could be layoffs. They could decide to exit certain markets, or Albertsons could be a takeover target for a different grocery company. And on the other hand, the FTC is saying that this is some sort of monopolistic push to try to raise prices and push down grocery store wages. And Alicia, one of those is correct and one of them is not.
Well, I think you can just look back over the evidence over the last couple of decades. And in terms of wholesale prices have actually risen much more than the consumer prices. And one reason has been the consolidation and competition. You've had a tremendous amount of supermarket consolidation over the last decade. And yet consumer prices have risen less than actual producer prices. And so that's one point to look at. Another anecdote is what happened exactly about, I guess it's now a decade ago, when the FTC actually swooped in. It okayed a merger between Albertsons and Safeway, which was the last big supermarket merger. But it said, well, you have to divest certain stores in order to prove it, to make sure that there isn't, quote unquote, excessive consolidation or excessive concentration under the HHI index that you mentioned earlier. So it required these companies to divest some of their stores to a competitor, it's basically stood up this new competitor, Hagen's, on the West Coast. And actually what happened was Hagen's wasn't able to remain competitive and ended up closing a lot of these stores anyways, which just shows the intense competition and what also the problems when you have regulatory intervention when they come in with these consent decrees and required divestments. I mean, maybe these Albertsons and Safeway could have made these stores competitive on their own, but maybe the market forces we're going to inevitably drive these layoffs and closures. And I think you have to be really, in some ways, cautious when the government intervenes in these markets, because the result can be actually more layoffs and more business destruction. And if these companies, if Albertsons and here Kroger aren't allowed to merge, I think you could see, maybe not immediately, but a few years down the line, more store closures as you see more competition from the likes of Aldi, Walmart, even Amazon. I mean, I would actually consider Albertsons probably a takeover of Amazon, which it would like to expand its footprint in the grocery business and has actually struggled. But, I'm not sure that Lina Khan, or even if there were a Trump administration and a regulator under Trump, would approve such merger. But the result it will be, if you have these stores closed, actually less competition.
Also remarkable is the FTC's record of court losses under Chair Lina Khan, including an attempt to block Microsoft's acquisition of Activision Blizzard. And then last week, in a federal court ruling saying that the FTC's broad 570-page rule on non-compete agreements is beyond its authority. And Monet, at some point, if Lina Khan keeps racking up these losses, the process maybe becomes the punishment. I mean, I don't know if the Albertsons and Kroger merger is going to win in court. Maybe it will. Maybe that merger will eventually go through. But at what cost to these employers? And at what delay to the merger?
Right. I think that the scale of the FTC's losses during the time that Lina Khan has been chair is evidence that she's ideologically motivated, as if we needed any more evidence of that. But the fact that she's willing to pursue these cases based on such thin legal reasoning, even after such a bad track record, suggests that bringing the case itself to signal to her supporters that they're taking the fight to these companies is a goal in and of itself for her. And also, as you mentioned, that they want to suppress merger activity by hanging a threat of a challenge, even if they know that it's far-fetched. And you can divide these losses into two groups. There are ones where there is an issue that the FTC does have authority to regulate, like anti-competitive actions. They simply haven't actually built their case and showed that there will be consumer harm. And I think Albertsons and Kroger is going to fall into that camp. But then there are also ones where they step completely outside of their authority and try to issue rules or make challenges on things that they aren't supposed to be regulating in the first place. And the rule on non-competes falls into that camp. And so we are seeing a uniquely unleashed federal agency right here, which is trying to basically make a statement about attacking corporate greed and is completely disregarding the thinness of the own legal arguments that it has to slap together to try to get there.
Alicia, we'll give you the last word, but can you provide a little bit more background on this non-compete rule and the court challenge there? Because I know you've looked at that one closely.
So this was a rule that came out this spring, and the FTC had actually been looking at these non-compete agreements for several years, and they are a bugaboo of the left because they allege that they suppress competition for workers. And the irony here is non-competes are actually most prevalent among high earners like tech companies, banks, and it's usually for the executive levels and intended to protect both intellectual property, but also investment in training. And usually, actually, by the way, if you're an executive or if you're a worker who has a non-compete agreement, you can usually negotiate if you want to quit and go work somewhere else. Employers are usually willing to negotiate an exit from these agreements. But here the FTC comes in, as is Ms. Khan's want, and basically bans them across the economy. Many states already have limitations or restrictions, especially for lower income, lower wage workers. But the FTC has basically come in and invoked its power to regulate, quote unquote, unfair methods of competition, which is really a very sweeping power. And to issue this rule that says, well, you guys, nobody can use these kinds of labor contracts. Now, this has drawn a lawsuit actually from numerous businesses. And what the judge ruled here in the case is, well, no, the Federal Trade Commission's prohibition against, quote unquote, unfair methods of competition merely allows the FTC to essentially issue cease and desist orders and go through its administrative process. It doesn't allow it to actually issue rules. It only provides a kind of enforcement authority. To bring this full circle, what I find is actually interesting here is that Kroger and Albertsons have recently actually challenged the FTC authority to actually even use its administrative tribunals to actually enforce this law against unfair methods of competition, saying, no, you actually have to go to federal court. This is under the SEC's Jarkessi precedent. So it may turn out to be that the FTC's powers to even regulate these non-compete agreements through its administrative tribunals and its enforcement powers are actually even more limited. And it may actually have to go to federal court if it wants to enjoin a company in select cases from using these.
Thank you, Alicia and Monet. Thank you all for listening. You can email your own merger lawsuits to pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.